Good morning, everyone. I would like to welcome you all to the June 14th, 2022 meeting of the Tennessee Board of Funeral Directors and Embalmers. Ms. Bohannon, would you please call the roll?
Fred Berry, Anthony Harris,
Here.
Tanya Scale Haynes,
Here.
Chris Lee,
Here.
Scotty Porsche,
Here.
Charles Rahm,
Here.
Pam Stevens. Mr. President, we have a quorum.
All right, thank you, Ms. Bohannon. Next item is the review and adoption of the agenda as presented.
So move.
Second.
I have a motion by Mr. Harris, a second by Mr. Lee to adopt the agenda. All in favor?
Aye.
Next item is the minutes from our previous meeting. I think all of you have had a chance to review those.
Make a motion we accept as presented.
Second.
I have a motion by Mr. Harris, a second by Mr. Lee to approve the minutes of the May 10th, 2022 meeting. All in favor?
Aye.
Next item on the agenda is the legal report. Mr. Bryant, turn it over to you.
First complaint is complaint number 2021-065901. An anonymous complainant submitted a complaint against Respondent Funeral Director alleging that they had been aiding and abetting unlicensed activity on behalf of a separate unlicensed funeral director. However, little additional information was provided, and with no way to contact complainant for further follow-up, the department was left without suitable evidence to proceed. Based on the above, due to the lack of specific information included in the complaint, there is no basis for the department to move forward in investigating the specific complaint. Therefore, we would recommend closure due to lack of evidence.
So if I read this right, the complainant wouldn't take calls or et cetera for information?
The complainant was entirely anonymous, did not provide their name, phone number, email address, any way that we could contact them.
I move we accept your recommendation for closure.
Second.
I have a motion by Mr. Harris, a second by Mr. Lee to accept the recommendation of closure. All in favor?
Aye.
Next complaint is complaint number 2022-006311. Complainant, father of the deceased, alleged unprofessional conduct on behalf of respondent, specifically stating that they had paid for services of transporting the body of the deceased to Honduras. Complainant stated that as of the date of the complaint, February 17th, 2022, they had not been informed that the body had arrived in Honduras. Due to the nature of the allegations, the department did not send the complaint for response and attempted to conduct an investigation immediately. However, despite numerous attempts, the investigator was unable to meet with complainant. Despite arranging a time and location to meet, and after several phone calls to the complainant, it became apparent to the investigator that the complainant was avoiding the investigator's calls and did not want to be interviewed. The investigator did learn that the complainant's son had arrived in Honduras, and based on the actions of the complainant, it appeared that complainant did not wish to continue the complaint. Therefore, legal would recommend closure due to lack of evidence and lack of cooperation from complainant.
Mr. Bryant, I have a question, and it may be one that Mr. Gribble needs to answer. Why did the department not send someone immediately? What kind of time delay was there in investigation?
The day we received that complaint, I drafted a request for investigation to send our field investigator out as quickly as possible. This has been a recurring situation where it appears when this comes in, we try and go as quickly as possible. But at some point along the line, the loved ones eventually get the services they contract for, and then at some point in the process decide to stop cooperating. So I guess to more directly answer your question, my recollection is that there was very little delay in sending an investigator out.
Do we know how long after the complaint was made that their loved one arrived in Honduras?
I am not sure of that. What I do know is that by the time our investigator went out there, it's, I guess, unfortunate in that sometimes there is a slight delay from the day the complaint is made to when it makes its process through and gets referred to legal. But by the time the investigator had attempted to contact the complainant, the loved one's remains had arrived in Honduras. The investigator learned that in the very brief conversations he had with the complainant. The investigator shared with me as well that the complainant was when they spoke on the phone, very wishy-washy of, well, I get off work at this time, I might be available to talk. Even at one point scheduled a meeting in which the investigator arrived at the complainant's apartment and he was not there. The investigator waited, I believe, about an hour and he never arrived.
Thank you. Any other questions?
I'll make a recommendation. We accept legal's recommendation of closure.
Second.
I have a motion by Mr. Harris, a second by Mr. Lee to accept the recommendation of closure. All in favor?
Next complaint number 2022008561. Complainant, friend of the deceased, filed a complaint against respondent for allegedly aiding and abetting unlicensed activity. Complainant also alleged that the body of the deceased was to be shipped back to Guatemala, but after a month of delay, respondent had yet to ship the remains as contracted. Due to the nature of the allegations, the department did not send this complaint for response and sent for investigation immediately. Although the investigator was able to speak to the complainant, shortly after the complainant informed the department that he wished to retract his complaint. According to complainant, the body had arrived in Guatemala as contracted for, and he no longer wished to move forward with the complaint. Despite the fact that the department attempted on numerous occasions to convince complainant to move forward with his complaint and provide further cooperation, complainant was adamant that he wished to retract his complaint and would not assist the department moving forward. Therefore, legal would recommend closure due to lack of evidence and cooperation of complainant.
If this isn't an appropriate question, let me know. It sounds awful familiar to the complaint above it. Is it proper to ask if it affected the same facility, which may have a pattern here?
It is the same facility. The facility is not a licensee with the state of Tennessee, but the funeral director is. So we don't have control over the establishment itself. That's correct.
Oh, essentially, he does not have an establishment. He's just, I guess, freelancing.
He does have an establishment. It is an establishment in Kentucky. But he does have a Tennessee funeral director's license in addition to a Kentucky license. And to just a little bit of context, the reason that these, I guess, three very similar complaints are kind of all popping up at the same time, legal has held on to these for as long as possible, hoping that complainant would change their mind or there would be something we could do to get cooperation from the complainants, and unfortunately it just has not worked out that way.
So with no cooperation from the complainant and no establishment to investigate the complaint, that's kind of where we're at now then, right?
That is correct.
So no response from a respondent then of why the delay? You're saying we couldn't get that information?
Due to the nature of kind of the, I guess, potential pattern and the nature of the allegations with how serious they were, the department did not send for a response. Essentially, kind of the I guess, nexus there would be once we had gotten sufficient cooperation from the complainant, the respondent would have had an opportunity to respond. But without that initial statement and cooperation from a complainant, there's just not much that the department can do to move forward.
Maybe I'm wrong on my thinking here, but since these two are mirroring each other by the same, would a letter of warning not even be justifiable here, or you're saying we can't because there's not an establishment?
Well, we definitely could issue a letter of warning to the funeral director, since the complaint was open against the director individually, who does have a Tennessee license. So that would certainly be within the purview of the board if that's something that you feel would be appropriate.
Harris, help me, I guess I'm still missing something in my mind. He was evidently meeting with families in Tennessee and arranging for shipment back to their home countries, but was he taking them back to Kentucky and doing all of this? Since there's no no physical place in Tennessee? And I may be missing something, guys. I'm sorry.
That is my understanding.
Okay.
Yes.
Okay.
I don't know. I just got a feeling here we should do a letter of warning instead of closure, because we've got a couple of the same deals here with delays. So I'm just going to step out and make a motion that we do a letter of warning against this funeral director instead of closure here.
I have a motion by Mr. Harris. To clarify, Mr. Harris, are you wanting to reference both situations in your letter of warning?
Can we do that since they're both the same? Or do we have to take each case separately?
Do have to be taken as separate complaints. If you would like to reopen number 2, in which to complaint number 2, in which to send a letter of warning as well, we need a 2/3 vote to do so.
And is the letter of warning, Mr. Harris, just based on time and efficiency with getting the ones back to where they're supposed to go? Is that
That's my point here.
okay?
Yeah. And both of them are against the funeral director, so if we do it just against this complaint only, I think it's still going to get his attention without opening number 2. So I say that we stay with number 3, Mr. President.
I have a motion from Mr. Harris for a letter of warning in regards to item 3. For a second.
Second.
I have a second. And I'm not sure who did. Second by Ms. Haynes. All in favor?
Aye.
Any opposed?
Next complaint is complaint number 2022006131. This complaint is a companion complaint to complaint number 2, as respondent to this complaint is an associate of respondent from the former complaint and was alleged to have been involved in the services contracted for. And so the recommendation would be the same as number 2, closure due to lack of evidence and lack of cooperation from the complainant.
So this complaint refers back to the funeral director we just sent a letter of warning to. Is that correct?
That is correct. So essentially, number 4 here and number 5. This is a previously licensed funeral director and embalmer who is alleged to have been associated. So essentially, in number 2, 2 and 4 go together, 3 and 5 go together. And this calls back to complaint number 2, where he was alleged to have been involved with the allegations related to that funeral director at number 2.
So if you're saying number 2 and 4 go together, do we have to retract number 2 if we do a letter of warning on 4? Or is there any use, in your opinion, since we've already put it on the last one? I think we're going to get the attention of the individual. Am I correct on my thinking?
Yes. And I think likewise it would be difficult to, where in number 2, since 2 and 4 go together, we did closure due to lack of evidence. If we were to issue a letter of warning on the assistant, whereas in number 2 it was closure, I think that would be difficult to do.
Any other comments?
I make a motion we accept legal's recommendation of closure.
Have a motion by Mr. Harris,
Second.
second by Mr. Porsche. All in favor?
Aye.
Complaint number 5, 2022008581. This complaint is a companion complaint to number 3, as respondent to this complaint is an associate to respondent from the former complaint and was the unlicensed funeral director whom the allegations claimed the former respondent was aiding and abetting unlicensed practice. And given the board's issuance of a letter of warning for number 3, I think it would be perfectly fair and reasonable to change this recommendation from closure to a letter of warning as well.
I'll move with that recommendation, letter of warning.
Have a motion by Mr. Harris,
Second.
second by Mr. Lee. All in favor?
Aye.
Next complaint, number 6, 2022009111. Complainant, Deceded Affairs at Vanderbilt University, filed a complaint alleging unlicensed practice on behalf of respondent, a previously licensed funeral director. Complainant alleged 2 allegations of unlicensed practice, one relating to a patient who informed complainant that respondent, not the funeral home, was responsible for funeral arrangements and transport of the deceased. The second involved a conversation in which the respondent communicated to the complainant that he was a translator for the family of the deceased. When complainant contacted the family member stated that they spoke English and did not need the services of a translator. Due to the nature of the allegations, the department did not send this complaint for response and attempted to conduct an investigation immediately. However, due to HIPAA confidentiality restrictions, the department could never obtain the names or contact information of the families whom the respondent had allegedly performed services for. As such, any evidence acquired in an investigation would be circumstantial and hearsay. It would not be admissible in a hearing. Therefore, we would recommend closure due to insufficient evidence.
Questions or comments?
So the initial complaint was by Deceded Affairs at Vanderbilt. The family never came forward or initiated a complaint at all.
That's correct. And we, I guess, 2 things on that to make the board aware of. I tried very hard to get around potential HIPAA confidentiality to receive contact information for the family to try and reach out and get a statement. HIPAA can be airtight sometimes, and unfortunately we're not able to do so. Likewise, we made it known to Deceded Affairs of how those family members could file a complaint if they chose to do so, and we made sure that those resources were made available, that if the families do ever come forward, they have an avenue and know how to do so.
So, as Chris was saying, Mr. Lee was saying, they filed the complaint but yet wouldn't provide the information that needed?
Due to HIPAA restrictions, since Deceded Affairs it operates as a medical facility, essentially, they were unable to provide the names and contact information to the family because of HIPAA confidentiality. And I spoke to their counsel several times regarding that, and I think we both tried to get creative, but unfortunately, we're not able to get that information.
I make a motion to accept legal's opinion of closure due to lack of evidence.
I have a motion by Ms. Stevens,
I'll second.
a second by Mr. Harris. All in favor?
Aye.
Next, complaint number 2022007311. This complaint is a companion complaint to two complaints from the previous legal report regarding allegations of unprofessional conduct relating to the size of the casket provided for the deceased. The board has already issued disciplinary action to the respondent for the same sets of facts and circumstances, and this complaint is identical to the previous two. Therefore, we would recommend closure since disciplinary action has already been issued to respondent for the facts and circumstances related to this complaint. And some additional context. Essentially, three members of the family all filed complaints. One came in, I think, about a week and a half later, which was just enough time to not make it on the last legal report, but made it onto this one. And they were copy and paste verbatim the exact same complaint.
Make a motion we accept legal's recommendation of closure.
Second.
I have a motion by Mr. Harris, a second by Mr. Lee. All in favor?
Aye.
Next, complaint number 2022010021. Complainant, sister of the deceased, alleged the following against respondent establishment. 1. The establishment's personnel lost, misplaced, or destroyed the deceased's personal property given to them from the coroner's office. 2. An employee informed complainant it would take 2 to 3 weeks for a VA burial, which resulted in the family's decision of cremating the deceased to avoid waiting that long. 3. Respondent falsely promised that the remains would be cremated within the next couple of days and sent to complainant. 4. The funeral director refused to send the deceased remains to complainant. Respondent replied to each of complainant's allegations stating, 1. Respondent had been transparent with complainant regarding the theft of the decedent's personal effects. Respondent stated that they had searched several times and never found the personal effects. Respondent stated that they offered their apology, $600, a free urn, and shipment of the cremated remains out of state to make amends. However, respondent stated that complainant rejected this offer and countered that respondent should compensate complainant by paying for their round-trip airfare, their 3-night hotel stay, and reimbursement for 3 days of car rental cost. Respondent declined this counteroffer. 2. Respondent stated that on December 14, 2021, the Department of Veteran Affairs supplied respondent with paperwork stating that the deceased discharge from the Army was categorized as OTH, other than honorable, and thus did not qualify for a free burial at Veterans Cemetery. 3. Respondent denied that they promised a cremation on this timeline due to the number of factors that go into acquiring a cremation permit. Respondent stated that in the case of the deceased cremation, the Illinois death certificate was filed with burial as a disposition method before the family amended it to cremation. Thus, the Illinois funeral home had to file an affidavit of correction with the state, thus pushing the deceased cremation timeline back even further. And 4. On March 7, 2022, the cremated remains of the deceased were express mailed via USPS. Respondent included the tracking information in their response. Respondent stated that the complainant received the delivery on March 8th. On March 10th, respondent claimed that complainant called respondent's office and insisted that she pay the shipping costs in the amount of $85.30. Respondent accepted her payment. This case was sent for investigation. The investigator spoke to complainant, owner and funeral director over the respondent establishment, and an apprentice funeral director who was heavily involved in the arrangements. Regarding the missing personal effects, complainant stated she requested respondent pick up the deceased personal effects during the transfer from Illinois. Complainant did state that she requested respondent reimburse her for travel to the deceased home in Illinois to compensate for the lost personal effects. Complainant attached a text message to show that these costs included $441 for airfare, $468 for a 3-night stay in a hotel, and $317.49 for car rental. The manager and funeral director of respondent establishment confirmed that they had received possession of the personal effects when they received the deceased from Illinois. The manager stated that when the establishment receives personal effects, they are placed in a locked drawer in the funeral home manager's office. The manager surmised that the desk drawer was accidentally left unlocked and that someone must have stolen the personal effects of the deceased. The manager stated that they have since placed a locking filing cabinet in the office to correct the situation. Manager stated that following the loss of the personal effects, complainant became difficult to communicate with, and that he had offered complainant $600 along with shipping of ashes and a free urn, but stated that complainant declined the offer and ultimately made her counteroffer for compensation for travel. The manager stated that he did not feel that he owed complainant the travel expenses, but that he did pay for the shipping of the cremated remains. However, the manager stated that complainant called the establishment on March 10th and insisted that she pay the shipping costs. Complainant stated that she inquired about having her brother buried in Veterans Cemetery in Memphis, but was told that due to COVID-19, it would take approximately 2 to 3 weeks to have her brother buried there. Complainant stated that she did not want to wait that long to bury the deceased, so agreed to have the funeral service and then have the deceased cremated after the service. Respondent added they soon received additional information to show that the deceased would not have been eligible to be buried in the Veterans Cemetery because his discharge was not honorable. Complainant stated that after the funeral service on December 21, 2021, she asked the apprentice funeral director when the deceased would be cremated. Complainant claims that he informed her that the body would be cremated in a couple of days and that he would select a nice urn and ship the remains to her out of state. The manager stated that the body of the deceased was delivered to the crematory on January 27, 2022. The manager stated there was a delay in delivering the body to the crematory because the original death certificate submitted to the Health Department of Illinois listed the disposition as burial and had to be amended to cremation. The manager stated that the Illinois Health Department would not issue the cremation permit until the death certificate was amended, which took some time. The manager added that the crematory had a backlog of cremations due to COVID-19. The manager stated that the body was cremated on January 27, 2022. The cremated remains were picked up from the crematory on February 4, 2022, and were mailed to complainant on March 7, 2022. And finally, complainant stated that she did receive the remains, that she should not have had to wait from December 22, 2021 until March 8, 2022 to receive them. An additional matter was discovered during the course of the investigation. On April 27, 2022, the investigator emailed complainant 3 documents obtained from respondent. The first was an authorization form signed by the unlicensed assistant dated on December 20, 2021. The second was a working copy of the death certificate that listed complainant as informant. And the final was an authorization for cremation and disposition. All 3 documents incorrectly spelled complainant's name, and the first and third documents were quote-unquote signed by complainant. Complainant stated that she never gave the unlicensed assistant nor any staff member at respondent establishment permission to sign her name on any documents. Complainant stated several times she never gave a written proxy or verbal permission for respondent staff to sign her name to any documents. When asked about this, the manager stated it was his understanding that the unlicensed assistant had been given proxy verbally by complainant to sign her name on the documents. The manager nor another licensed funeral director in the establishment admitted to signing complainant's name. The investigator also spoke to the apprentice funeral director, who admitted that the documents were not signed by complainant, but said that he had communicated with complainant about signing the documents so that the process would be expedited. The unlicensed assistant denied signing the documents and claimed that he was not sure who had, but thought it might have been one of the secretaries. Additionally, complainant stated that she had never received a statement of funeral goods and services for the selected contract. The manager stated that neither he nor the apprentice funeral director recalled complainant requesting a statement of funeral goods and services because most of the arrangements were made over the phone and by text. Based on all of the above, legal would recommend a $3,000 civil penalty plus the cost of investigation, authorized via consent order and formal hearing if necessary.
I know that was a lot to absorb. Are there any questions or concerns in regards to this case?
My mind is spinning, so couple questions here that I've notated. Was there a reason why it took them 1 week to pick up the cremated remains first?
There was nothing provided regarding that delay. Additionally, I noted upon receiving the investigatory memorandum that there was also no explanation as to why they picked up the cremated remains in early February and did not ship them out until early March.
That was going to be my next question. Why a month to send out? Anybody question the secretary about these signatures that they're denying who signed, but it was expressed there possibly the secretaries? Anybody question?
My understanding from the investigators' discussion is that the unlicensed or the assistant funeral director did not even specify which secretary. Just, I think it may have been one of the secretaries. I do know that the investigator asked many times with the manager and the assistant funeral director. The secretaries themselves weren't asked, but I think that's more so because the assistant couldn't even specify which secretary may have signed it.
I don't see a secretary just picking up a form and signing it. Somebody knew what was going on, and I can't see through that. They're not just going to pick up a document and just sign it. I was almost kind of leaning toward understanding about the burial and the time delay, and then dishonorably discharged. But when we get down into this paperwork and all, I've got a grave concern with that. Just curious, what the personal effects were?
The complaint included a list that I don't think was cumulative. I don't think it covered everything, but I do note it included the deceased driver's license, the deceased's social security card. I think he had a like a golden medallion, kind of personal effects like jewelry and things
I
like
was
that.
just wondering where he kind of came up with the $600 he offered to pay back.
If I'm reading this correctly, they also weren't up front to say that the delay with the VA was because they were investigating the discharge issue.
I think regarding the VA issue, I didn't see that as a violation. I think that they received that documentation later that the discharge was not honorable and thus wouldn't have been prone for a free burial in the VA cemetery.
Give me an idea of what the civil penalty, what fault that penalty is going to in the complaint overall. What did we decide that that warranted that? Like I said, there were several complaints and several answers, just unprofessional conduct or possible forgery, or I mean, just
Specifically, 2 instances of potential forgery with both the first and third documents that were provided, the lost effects, the delayed shipping that did not have any explanation associated with it, and a not providing a statement of funeral goods and services.
thank you. That I was trying to.
Was the manager the actual funeral director of this case?
Yes, that is correct.
And is the apprentice serving under that manager?
Yes.
Complaints against the establishment, right?
That is correct.
Okay. I get
Is there a complaint against the manager?
There is not. It was a complaint filed only against the establishment.
This might be a wrong question, but do we have the right with this penalty to do like a 6-month probation or something where that manager is watched in case something like this comes up again? I don't know if that's a fair question or not.
There is, to my knowledge, not a way in which we could do something specific, I guess, as specific as a probationary period, but if something from this establishment were to come up again, I would recognize and recall this complaint, and that's something I can definitely appraise the board of at the next time. I guess a kind of formal disciplinary probationary period, I guess, doesn't have, I think it would be difficult to do, but it's something that would not only pop up in this establishment's disciplinary history moving forward, that if another issue such as this occurred, I would, on the legal report, let the board know to tie it back to this complaint as well.
Could the manager and the apprentice be given a letter of warning?
I believe since there was not a complaint open, we are limited. 1 second, let me check.
I was kind of same thing. Seemed like the apprentice kind of handled this front to back when the manager, didn't even know if he had property or what. Like
it's essentially we're kind of, almost at the mercy of the complaint that the complaint opened. And since the complaint was opened against the establishment, within the confines of this specific complaint, we would not be able to issue disciplinary action for the individual licensees.
I feel like the $3,000 is in line for this big of a. This is pretty big in my eyes.
Certainly is, and I will also add that the investigation costs are fairly significant as well. That the in addition to the $3,000, there is a fairly substantial amount coming with the cost of investigation as well. But if the board feels that a larger civil penalty is appropriate, that's perfectly fine.
I'm going to step out on the limb here because this has a lot of wrong in my eyes. I'm going to make the motion we bump that up to $5,000.
I have a motion by Mr. Harris to increase the civil penalty to $5,000 plus the cost of investigation, authorized via consent order and a formal hearing. Is there a second?
Second.
I have a second by Ms. Stevens. All in favor? Any opposed?
President,
Was it? Y'all are gonna. I got bad hearing, so I apologize.
She beat me to it.
All right, the next complaint is complaint number 20220111411. Complainant, a florist company, alleged unprofessional conduct on behalf of respondent establishment. Specifically, complainant stated that on November 9th, 2021, the family of a decedent contracted them to provide flowers for their mother's funeral. Complainant then contacted the owner of respondent establishment, who agreed to be billed for the flowers. Complainant stated respondent informed them that there was a life insurance policy and that they would be responsible for the bill. Complainant stated that he was contacted by the owner and told that they would be sending a check. Complainant further stated that that several months had gone by and that they had faxed and mailed bills to respondent and still had not received payment. Respondent replied stating that due to complications with the insurance company, the family was not able to fax the paperwork to the insurance company until the last week in December. Respondent stated on February 1st, 2022, they received checks for the services of the deceased and made the deposit the same day. Respondent stated that the check to complainant was not written this day as it should have been, but added that it takes a couple of weeks sometimes for payments received to be recorded and checks to vendors to be written. On February 13th, 2022, respondent stated they received another invoice from complainant. Respondent stated he realized the check had not been written, and he informed an employee to write a check to complainant and mail it to him. On March 14th, respondent received another invoice from complainant. Respondent checked the checkbook and noticed that the check had still not been written. Respondent asked the employee, who said that the insurance company had still not paid the claim. Respondent stated he knew that this was not the case since he had written the receipt for it and deposited the check. Respondent maintained that because the payments had not been entered into the paper record book, the employee had assumed that it had not been paid yet. On that day, respondent mailed the check to complainant and called complainant stating that the check was in the mail. When respondent was alerted on May 9th, 2022 that a complaint had been filed, respondent checked his bank to determine if the check had cleared. Respondent discovered that the check had cleared their bank on March 29th, 2022, and that the complaint had been filed on March 22nd, 2022. Respondent attached documentation to show that the check had been sent and that the complainant's invoice had been paid in full. Legal spoke to complainant on June 7th and confirmed that they had received payment shortly after the complaint had been filed. Based on the above, legal would recommend a letter of warning.
Comments or questions?
Looking at 4 months, I think, if establishment is going to offer cash advances, and they need to, pay their bills. They're letting them, have products before they're paid. Talking with the complainant, do you feel that he is satisfied now as far as?
Yes, I got the impression that was the case. I spoke to him for several minutes, probably about 5 minutes or so, and he seemed satisfied that it had been paid.
I'll make a recommendation to accept council's letter of warning.
I have a motion by Mr. Lee,
Second.
second by Mr. Porch. All in favor?
Aye.
Next complaint numbers are filed together. They are complaint numbers 2022-012331 against the funeral establishment and 2022-012231 against the funeral director. Complainant, daughter of the decedent, alleged unprofessional conduct on behalf of both the respondent funeral director and establishment. Specifically, complainant alleged that they had been trying to get a death certificate for the deceased since their service on November 2nd, 2020. Complainant stated that every time they speak with respondent, they are told that they are working on it. Respondent did not respond to the complaint. Based on the above allegations of unprofessional conduct and for failure to respond to the complaint, legal recommends a $1,500 penalty to be assessed equally as a $750 penalty against the funeral establishment license and the funeral director's license, respectively. Authorized via consent order and formal hearing if necessary.
So you're saying we did not get response from the manager or the funeral director, correct?
That is correct.
By chance know the status of the death certificate?
We do not. Since the respondent did not reply, essentially the alleged information is taken as true, and that the issue regarding the death certificate was accepted as it was presented.
Y'all notice this is 2020, not 2021. Do we know when? I mean, that's if they filed the complaint, I'm assuming in 2022.
That is correct.
So they've been going at least a year or more without getting the death certificate before the complaint was filed. If I'm reading that correct. Part of me would like to know from the family if they've gotten the death certificate. Before we close out anything, I'd like to make sure that they got what they needed.
And
It really bothers me that we didn't get a response more than that itself.
I agree with that. And this is my mistake. This is something I should have included in the summary, but my recollection is that this death occurred out of state as well, occurred in Mississippi. But I certainly understand the board's interest in determining that current status. So if I'm happy to contact the complainant and gather that information.
My opinion, I don't feel like the fine we're putting on them is significant enough due to their history, especially since they didn't respond. That's a lack of their duty. So I'm going to recommend with a motion that we go with 2,000 equally dividing out 1,000 per. But I would also like a update to make sure the family has received the death certificate that they should have received.
I have a motion by Mr. Harris to increase the civil penalties to 1,000 each, 1,000 for the funeral established, and 1,000 to the funeral director.
Second.
And I have a second by Mrs. Stevens. All in favor?
Just to clarify in terms of taking care of this, so hypothetically, if I contact the complainant and they say, no, we have not gotten the death certificate, as opposed to moving forward with 1,000 each, would the board prefer at the next board meeting I represent that and the board determine at that time whether...
Absolutely.
Okay.
In my opinion, I can only speak for me.
Yes, I think that would be best.
Okay, next complaint is complaint number 2022012801. Complainant, sister of the deceased, stated that her sister passed away on November 4th, 2016, and that respondent was responsible for their final care. Complainant stated that unbeknownst to her, respondent was not paid for the entire cost of the services. Complainant alleged that respondent sent the family pictures of the, quote, naked, cancer-ridden body of the deceased, stating that, quote, this is what he had to work with, while requesting complete payment. Respondent replied stating that back in October of 2016, arrangements for the deceased were done over the phone and the payment policy was explained. Respondent stated that prior to the service day, the establishment had advanced upfront a charge of $8,495.96, despite the fact the family had yet to pay any of the services costs. Respondent stated that despite this, the service proceeded. Respondent further stated that the deceased had had a life insurance policy, but that the beneficiaries, the mother of the deceased and the daughter of the deceased, had not tendered any money for payment. Respondent maintained that he did show a facial picture of the deceased to the cousin of the deceased, who is a friend of the respondent's, and the cousin's sister to show the condition in which he had received of the deceased and the work that he had done to, quote, make her look presentable for her family. Respondent stated that the total funeral and burial services provided were $18,063.96, and that to date he had only received $6,232.78 of payment. Respondent added that the family had recently received a bill for the remaining balance, which provided the motivation to file the complaint. Based on the above, we would recommend a $1,500 civil penalty, authorized via consent order and formal hearing if necessary.
Mr. Bryant, were we able to confirm that the respondent sent the pictures of a naked body?
The respondent admitted to sending pictures of the deceased. There are differing stories as to, I guess, what specifically the picture contained and what caption was assigned with the pictures, but the respondent admitted to, I have it written out here, one second. Admitted to showing a facial picture of the deceased that he sent to the cousin of the deceased and that cousin's sister.
What do you think worked Uprise in the last 6 years? Did he try to collect payment after 6 years? I'm just guessing.
That is my understanding, that he very recently sent a invoice reminding them that you owe this amount of money, and that sparked the complaint.
Which then opens that wound all over again for them with the grief.
again, I'm new to the board, but are these monetary penalties enough to teach someone that sending a picture of loved ones on a phone is so unprofessional? And I mean, morale. I mean, I can't even think of a word that anybody in our profession would do. And it looks like from prior history, their funeral home has been in disarray and casket lists, and now sending pictures. Is that what this board is here for? Are we here to try to well, I know we can't fix these problems, but there needs to be a message sent to people that are claiming to be in our profession, but putting a bad light on the rest of us.
I'm going to play the new card again and ask one question. This was filed against the funeral establishment.
That is correct.
Is that because when the complaint was initiated by a member of the public, they filed the complaint against the establishment and not a funeral director? Or do we do anything to deter how that goes?
When they file the complaint, they designate whether the complaint is against the establishment
Or funeral director?
That is correct.
But it seems to me, do you punish the establishment if this was maybe a non-manager funeral director that's not going to reap any of the repercussion here? I guess is my thinking.
And in this case, the funeral director owns this
Owns the
establishment.
funeral home.
So,
Yeah.
and one thing I do want to make aware, since I know we have, a couple of newer board members, is that statutorily the civil penalty limitation is $1,000 per day per violation. So essentially, while I certainly understand the sentiment, and I guess there are two things I want to. The first is that when I recommend civil penalties, if I kind of look at the situation, and I will, me personally, just as kind of how I handle it, will be more prone to recommend a more conservative rather than aggressive. And if you guys, since you know infinitely more about the business than I do, will know if the aggressive is more appropriate. With that being said, I would say that there are two violations here, since he sent the photographs to two separate people. So I think based on the statutory limitations, the maximum that would be allowed under the applicable statutes and laws would be a $2,000 penalty, which is the violation of sending the photograph to the cousin of the deceased and then the sister to that cousin. Two separate people, two actions, two violations, $1,000 is the statutory maximum.
That makes a lot of sense to me. Thank you.
Ms. Stevens, thank you for your comments, because I totally agree. And I think we got to get some attention of folks in our industry. So you're saying that the max here would be 2,000?
That is correct.
Then I'm going to move with a motion that we do the max of 2,000 here on this penalty.
I have a motion by Mr. Harris to increase the penalty to 2,000. Second. Second by Ms. Haynes. All in favor?
Aye.
Any opposed?
And I suppose since we're on the topic of civil penalties, I'll read very briefly the applicable rules regarding it. So subsection 2 states essentially what I said earlier: each day of a continued violation shall constitute a separate violation. And subsection 3 says, in determining the amount of a civil penalty to be assessed pursuant to this rule, the board may consider such factors as the following: A, whether the amount imposed will be a substantial economic deterrent to the violator; B, the circumstances leading to the violation; C, the severity of the violation and risk of harm to the public; D, the economic benefits gained by the violator as a result of non-compliance; E, whether the violator has been guilty of similar actions in the past and any discipline imposed for past violations, F, the interests of the public, and G, the length of time that has elapsed between the alleged violation and filing of the complaint. So those are essentially the things that the board may consider when coming to a resolution of a civil penalty, more just for the, I guess, edification of the application of civil penalties.
Ask a question right there. That's
Sure.
a lot of great information. Is there any way that that could be emailed to us?
Absolutely. Yeah.
Because
I would be
that's good to hear that.
happy to do that. Number 13, complaint number 2022015491. Complainant, mother of the deceased, filed a complaint alleging unprofessional conduct. Specifically, complainant stated that respondent had provided services to the deceased and stated to, quote, pay what you could when you could. Complainant alleged that respondent and employees from the funeral home began harassing her regarding payment. An attorney replied on behalf of respondent stating that respondent is actually the nephew of complainant, and due to their familial relationship, respondent provided services at a greatly discounted rate. Respondent further stated that although complainant had verbally promised to be responsible for the expenses, ultimately another family member signed the service contract legally obligating them to be the financially responsible party. Respondent attached documentation to show that this was the case. Respondent stated that after the services were provided, complainant refused to pay as promised. Respondent denies that at any time they violated the rules of professional conduct, and further stated that they do not assert that complainant is responsible for the debt, nor are they attempting to collect the debt from complainant. Based on the above, we would recommend closure.
So if the complainant wasn't the responsible party for this debt, do we know who was?
Yes, it was another family member. I actually spoke to the attorney this morning. I believe it was well, I don't want to misstate, but it was another family member that was closely related. And speaking with the attorney this morning, she said that the complainant had contacted, or excuse me, the respondent had contacted the complainant saying just following up on payment. And then when eventually he spoke to his attorney, she said, hey, you know, the responsible party, we've got a contract here, so we just need to talk to them about payment instead. And since then, they have maintained that they're not attempting to collect the payment from complainant.
That being the case, I'll make the motion we accept legal's recommendation of closure.
Second.
I have a motion by Mr. Harris, a second by Ms. Stevens. All in favor?
Aye.
Next complaint is complaint number 2022017761. This complaint was administratively opened on May 2nd, 2022, regarding advertisements on Respondent Establishment's website. Specifically, despite several courtesy communications with the general manager of the Respondent Establishment that had been ongoing since January, the website still contained an advertisement for, quote, simple cremation starting at $795, end quote, without itemizing the services and without providing the price of each service. Although the general price list was available on the website for potential customers to access, the initial advertisement seen on the respondent's website showed only, quote, simple cremation starting at $795 without itemization or the individual price of each service. On May 11th, 2022, an attorney replied on behalf of respondent stating that they had interpreted the word advertisement in applicable rules and statutes to include the website as a whole and not an individual screenshot of the website. Given this interpretation, respondent believed that the link below the advertisement of simple cremation starting at $795 that stated, quote, find out more, that linked to the respondent's general price list was sufficient for compliance. On May 20th, 2022, the website had been changed to include an itemized price list under the advertisement, and denoted what services would be provided. Based on the above, although respondent's website is currently in compliance with the applicable rules and statutes, the change in the advertisement occurred only after communications informing respondent of the violation that dated nearly 4 months prior. Despite the earlier communications, the change was not made until May 20th, 2022, nearly 4 months after the department first communicated with the respondent. Based on the above, we would recommend a $250 civil penalty, authorized via consent order, and formal hearing if necessary.
I think with the state reaching out and trying to offer them the chance to make it right back in January, and they go almost 5 months and didn't change anything until they got the complaint, I'll make a motion that legal's recommendation of a $250 civil penalty.
I have a motion from Mr. Lee to accept the recommendation.
Second.
I have a second by Mr. All in favor?
Aye.
And the final one is a represent from the previous board meeting, complaint number 2022008101. This matter was previously presented to the board at its May 10th, 2022 as follows. Complainant, a competitor of the respondent establishment, alleged unprofessional conduct on behalf of respondent. Specifically, complainant stated that they had worked with a particular family for hours on services and that all arrangements were completed. Complainant further stated that the family met with respondents to secure a grave space, opening and closing, and other burial services. However, complainant stated that there was a funeral home attached to the cemetery and that the funeral home offered them a free opening and closing in order to switch to their services. Complainant alleges that respondent's director called to inform them that the family would be switching to their service. Complainant stated that they had worked extensively with the family and they owed their basic services charge. Complainant alleges that respondent refused to pay for the charge and then used the obituary complainant wrote, used the same casket, and emulated the other services that complainant was going to provide. Complainant stated that it was unfair that they had worked for free when respondent refused to pay them for their services that the family had already rendered, and further alleged that respondent had solicited that family away from their business. Respondent replied and denied the allegation that they had solicited the family away from complainant. Respondent claimed that during their meetings with the family inquired about their offering of a free opening and closing when using their funeral home. The employee directed the family to a funeral director at the respondent establishment, and respondent stated that the family indicated that they were interested in a comparison of the services between the complainant and respondent funeral homes. Respondent reiterated that the funeral director only answered questions posed to him by the family and never solicited the free opening and closing. Respondent stated that the family later chose to meet with another funeral director of their own volition, and they began to compare specifics of the contract with the complainant funeral home and the offerings of the respondent funeral home. Respondent attached to their response a letter from the member of the family that corroborated respondent's versions of events, adding that they had used the same outline for the obituary that they had already helped put together for complainant's establishment. The family member stated that they were very appreciative of respondent's services and corroborated that they were not solicited by the respondent. And at that meeting, we recommended closure. It was referred back to legal to determine from complainant whether services were paid for, and if any were unpaid, how much payment is outstanding. I spoke with the complainant and determined that the respondent had reimbursed complainant in the amount of $325 for the removal costs of the decedent. And as such, we would recommend closure.
Thank you for following up on that. I do recall that one, and I make the motion we accept legal's recommendation of closure.
I have a motion by Mr. Harris,
Second.
second by Mr. Lee. All in favor?
Aye.
Mr. Bryant, thank you.
Thank you.
Item on our agenda is the Executive Director's report. Mr. Gribble?
Morning, board members. First, we have the legislative update, and last month we gave you the two public chapters we had, and one at that point had been transferred to the governor for his authorization, for his action, and he did sign the bill, and there's a public chapter for that one as well. So what we're doing now, we're in the process of consulting with legal and administration and implementing those necessary changes in core, and we intend to send some kind of notification out to the funeral homes and funeral directors that a funeral director no longer has to register as a pre-need sales agent. So if you, I'm saying this for the benefit of people who might watch the meeting as well, if you know of someone who is a funeral director, has an active funeral director's license, and that's about to expire, there's no reason to renew that. Nor if you have a funeral director who wishes to sell pre-need funeral contracts, there's no reason to apply for a pre-need sales agent registration. However, we need to be very clear that if the pre-need funeral contract is going to be funded by an insurance product, then the funeral director is still required to have an insurance producer's license through the insurance division of the department. And should the funeral director's license expire, lapse, or become inactive for any reason, or if it's suspended or revoked, then that funeral director would be in violation if they were to write pre-need funeral contracts while their funeral director license is not active. So that's what we're trying to communicate. That's what we was at the attended the Tennessee Funeral Directors Association convention last Monday, and of course Mr. Batson's here today, their executive director, and their lobbyist and their person in charge of their legislative committee gave a report about that, and I just clarified those things that I just mentioned there. So that's the communication we're trying to get out on that part. And then the other part is about the continuing education. For anyone whose license is renewing, then they're to have 10 hours of continuing education, and 5 of those must be in person or interactive as defined by the new law. And of course, I'm summarizing and not reading from the law, but basically it's either in person or where there's a constant two-way communication or consistent two-way communication between the provider and the licensee, and that is normally affected through Teams, WebEx, or Zoom. And so 5 of the 10 hours, and the licensee will need to make an attestation when they renew their license through CORE that they have those 5 hours, and to attest to that and not have the 5 hours in that manner would be a violation as well. I think those are the main things that we're working on as far as legislation. The licensee report you have before you, a report of licenses that are administratively approved by the executive director pursuant to the board authority for the period of May 7, 2022 through June 12, 2022. Closed establishment report. There's one establishment reported closing. That's Sadler Funeral Home and Crematory Services, 130 Trousdale Ferry Pike in Lebanon, Tennessee. And just so you know, when we report these to you as reported closing, they have signed a form where they have voluntarily surrendered their establishment license, or we don't report that to you. Otherwise, we don't make the determination. That's made by the licensee that they're closed. The disciplinary action report is the report of consent orders that have been administratively accepted or approved by the executive director pursuant to board authority, and as reported on the April 2022 regulatory board disciplinary action report. Those respondents, their location, violation, and the civil penalty amounts are reported there as well. And the complaint report as of June 9, 2022, there were a total of 28 complaints. 15 of those were either funeral directors or embalmers, and 13 against establishments. And that concludes my report. I'll be glad to answer any questions you have.
That 28, Mr. Robert, is that what's open right now, or just the newest complaints opened? The 28.
And Ms. Bohannon can answer that probably better than I can.
Those are the complaints that are currently open.
I have a motion to accept the executive director's report.
So move.
By Mr. Harris,
Second.
Second by Ms. Stevens. All in favor?
Aye.
Application for licensure. It's my understanding we don't have any individuals or establishments. New business.
One question here, be for legal. I know used to we got our legal reports on Friday. Is there any possible way that could be done again? I know getting it late yesterday after I got into town, it's just hard to read through this and have great notes and be ready for this meeting.
No, absolutely, and I apologize for that. That no excuse on that, and I will definitely start getting it to the board earlier.
Appreciate you.
Any other business? Motion to adjourn.
So move.
Motion by Mr. Harris, second by Ms. Stevens. All in favor?
Aye.
We're adjourned.